the property management industry, fair housing offenses are considered especially troubling. In the United States, a dedicated fair housing attorney, Leslie Tucker, provides case explanations and best practices. These are some cases.
Hello, everyone. Welcome to Case Files, where we break down real fair housing cases and talk about what went wrong so you can avoid costly mistakes on your own properties. My name is Jonathan Sarr, and I am joined by my colleague and fair housing expert, Leslie Tucker, who is also a national speaker. Thank you for being here, Leslie. It's good to have you again, as always. So, what case are we talking about today, Leslie? Give us an overview, please.
Sure. Good to be here, Jonathan. Today, we are diving into a pretty recent case and a very relevant case, United States versus Five Properties LLC, doing business as Taunty Management. Like I said, I think it's a very relevant case because it involves a verification obtained from a remote healthcare provider found online, which I know that many of you out there, housing providers, you find to be a challenge.
Absolutely. I've lost count on how many episodes we've had this topic come up when it comes to ESA and verification. So, but this case, it seems, is a nice example of how things can just kind of spiral out of control when communication breaks down between the resident and management. So can you give us some background to the case, please?
Sure. So in this case, the resident at issue, her name is Dory, she moved into Sun Lake Apartments in Kenner, Louisiana, this was back in 2018. At that time, she did have a dog. Her name was Sasha, but the dog, Sasha, was over the weight limit per the property's rules. So Sasha moved in with Dory's parents while Dory moved into her new apartment.
Okay. Thank you for the overview. And so I was noticing some other things in the complaint. It states that Dory had been previously treated for severe depression, anxiety, and ADHD. The complaint says that after moving in, her symptoms worsened. She reached out to her primary doctor for an emotional support letter, but the doctor had a policy against writing them. So what are your thoughts?
Right. And we hear that, it's not uncommon to hear that. And as many people do, Dory turned to an online service and was connected with a licensed out-of-state social worker who claims that then he interviewed Dory by phone and then subsequently provided a letter stating that the dog was essential for her emotional health and well-being.
Okay. And so carrying on with some of the stuff in the case, Dory submitted her ESA request along with a social worker's letter and medical records documenting her previous treatment. The complaint says the management company's legal team questioned the validity of the social worker's letter, essentially calling it an internet purchase.
Right. The defendant's attorney, the property's attorney, sent a letter shortly thereafter denying the request, basically saying that because she hadn't been seen by that social worker and only spoke briefly by phone, as is, the practice for many of these types of providers. The legal team for the property also kind of made an assumption that her own doctor refused to write a letter for her because maybe that doctor thought that the ESA didn't really have any therapeutic benefit for her.
So lots of back and forth we're seeing. A tip for our audience? Do you have something, Leslie?
I do. And I think this is really important because I know so many of you find yourselves in these situations where you are presented with this letter that you read and are immediately suspect, of its legitimacy. Mm-hmm. My pro tip is this: be careful about automatically dismissing or denying a request because the verification document originated online or through, a telehealth provider. In today's world, we know telehealth is very common. It's a legitimate medical practice. So even though a verification letter may appear to be purchased or an internet letter, and we kind of all know what those look like and the language that's contained in those, automatically denying that request without inquiring further, asking more questions is pretty high risk.
Okay. That's an excellent tip. So make sure, community, please jot that down. Good points to remember. So anything else from the case you want to share?
Right. So we don't stop there. Of course, there's more. So while her request was being evaluated by the property and their legal team, and this was before it had been denied, Dory claims that she had a severe anxiety attack. And because of that, brought the dog onto the property, into her unit, prior to receiving any decision on the request.
Okay. And it seems like, according to the complaint, that management, they reacted pretty quickly on that. They assessed her with $600 fees, $450 security deposit, and gave her 24 hours to pay or they would start eviction proceedings. It's interesting.
Yeah, and this is an important point because these fees are supported by the lease. The lease and their policies specifically talk about these fees for bringing an unauthorized animal onto the property. Landlords have this right to implement and enforce rules regarding animals in their community rules, in their lease, and that might include fines at times, and that's okay. However, it's honestly a business decision for a company to impose those fines, especially in such a high amount, to an individual who has made an ESA request and whose request was still being reviewed at that time. So although the rules may be clear about the requirement for an animal to be approved before they, are brought onto the premises, be aware that threatening eviction and charging steep fees, while that request is still pending or maybe immediately after a denial, you really probably open the door to potential interference or retaliation claims under the Fair Housing Act.
Okay. Again, super important points for our audience to keep in mind. And again, the complaint saying that Dory, she was prepared to go to HUD, but the management company stood their ground and allegedly demanded the money within 48 hours and threatening eviction. Okay.
Correct. Yeah, that is what she alleges. And she does say that she did move the dog back into her parents' house because she couldn't pay the fines. But basically at that point, she says for her, the damage was done and she filed a HUD complaint and a federal lawsuit shortly after that.
Okay. Wow. This is a lot of details in this case. And it looks like things took a turn for Dory. She alleges that the stress of this situation led to her being admitted into an inpatient facility for suicidal ideation.
Right. And she says while she was in the hospital, her treating psychiatrist, not the online social worker, but the physician or the psychiatrist that was treating her while she was hospitalized, did write her a new letter confirming her diagnosis, talking about the necessity about the assistance animal for her, to live with that dog. And then her lawyer sent this new letter to the management company and said, can you please reconsider this decision? She really needs this dog.
Okay. And so how did the defendant company respond? Did they find that to be sufficient?
Not exactly. They did receive the letter, but they did say, we need authorization to reach out directly to this psychiatrist. We need to verify the information that's in this letter. That disagreement regarding the new verification occurred maybe 2 or 3 days right before her eviction hearing. So that kind of went through before any decision was made on the renewed request.
Okay. Okay. So the court entered a judgment for the property, and Dory was required to vacate the unit, although the court denied the management company's claim for money due under the lease. So what happened next?
So fast forward to 2025. Remember, she had filed a HUD complaint. HUD did investigate that complaint. They found reasonable cause to believe that the defendants violated the Fair Housing Act, and that ultimately resulted in this lawsuit alleging discrimination and retaliation.
Okay. Yeah, because I think at the beginning we said this is this is a few years ago when this all started to happen, and now the repercussions are recent. So let's recap some of the questionable decisions made in this case, or comments from you. What would you share with our audience, Leslie?
I think that let's start with the initial verification. So the social worker's letter. Dismissing the social worker's letter kind of as a scam, as an internet letter, without attempting to learn more was a questionable decision, potentially. We know that there's no shortage of internet providers who write letters without any shred of knowledge of the person that is requesting it. We know this. However, without asking some additional questions of that verifier, to determine whether there is that knowledge, whether there is that reliability, housing providers can't know for sure if that letter is legitimate, right? So that's kind of the first decision that potentially questionable. The second is that levying these fees, these fines, and threatening eviction, within 24 hours, while an accommodation request was pending, that may have been supported by the lease, but could have, been a risk under the Fair Housing Act, just the timing of that. And then lastly, the new information that was given, a little bit down the road. When the psychiatrist treating her in the hospital provided the letter, maybe should have been considered reliable and current, considering, the circumstances behind it. And whether, new information or additional verification beyond that should have been requested, again, potentially questionable. I just want to make a quick note regarding these comments that I'm giving. There are obviously, two sides to every story, to every case. I very much recognize that this housing provider probably had its own reasons for the actions that it took that we just may not be privy to, based on the information online. So these tips are not in any way intended to imply that what they did was a violation of the law. Obviously, the United States has to prove that in this case. And they are asking for a court order to declare these actions illegal. And of course, they're asking for monetary damages for Dory.
Okay. Yeah. That's important to share with the community. So thank you for doing that. Really, we bring these cases for all of us to learn from them. And it's not to single any particular group out by any means. So yeah, thank you for sharing that. That's a really important point, Leslie. Thank you, everyone. We're grateful to have you on this episode of Case Files. We hope this helps you, gives some context. And Leslie, as always, thank you for your insights and your comments on cases like this.
Yeah, always a pleasure. Thanks, Jonathan.
And to our listeners, remember, stay educated, stay compliant. We'll see you next time. And we appreciate so much your supporting this community. We could not do it without you. So until next time, take care, everyone.